Ready? Start. I have considered all the relevant contention. The records have been perused by me. I shall now proceed to advert to the various contentions raised by the learned counsel for the rival contestants. First of all, there is an attempt to contend that the parties had agreed that an application under Section 125 CRPC would be maintainable. This is evident from the judgment dated 3/4/1997 in MFA number 697/96. It is contended a copy of the same has been marked as Exhibit P2, and I have already extracted the relevant statements in para 2 of the said judgment. I am unable to agree that the said agreement would in any way advance the case of either contestant. What is agreed to extract the word of the division bench was as follows. It is also agreed between the parties that the disposal of this appeal will not prejudice the right of the respondent to claim maintenance separately under Section 125 of the CRPC. This agreement does not at all amount to any admission of the existence of a right or otherwise to claim maintenance under Section 125 CRPC. It is only means that the claim can be raised and the same will have to be disposed of in accordance with law. The agreement referred to in Exhibit P2 cannot, in these circumstances, advance the case of either party. Secondly, there is a contention that the respondent having secured a decree for judicial separation, the same must be reckoned as a decree for divorce, and consequently the wife would fall within the sweep of explanation B to Section 125 CRPC. It is contended that if a wife whose husband has secured a decree for divorce against his wife under Section 10 of the Indian Divorce Act would fall within the sweep of explanation B, a wife against whom a decree for judicial separation has been passed must also be held entitled to such a relief. Reliance is placed on the decision of this court. The learned counsel for the respondent promptly points out that this contention is not available as a later single judge decision of this court in Thomas Kuriakos versus Abraham Mary in bracket 2003 in bracket 2 KLT 41 bracket close has chosen not to follow the decision in 2001 in bracket 2 KLT SN 44 and has taken the view that the decree for judicial separation cannot be equated to a decree for divorce. I am in complete agreement with the decision in Thomas Kuriakos in bracket supra. In a decree for judicial separation, the marital tie remains intact without severance. That is the crucial distinction between a decree for judicial separation and a decree for divorce. It is crucial to note that a decree for divorce, a mensa et toro, is not equivalent to a decree for divorce. The mere fact that under the English law as amended later a decree for divorce, a mensa et toro, has been recognized as a decree for divorce is no reason for this court to equate a decree for judicial separation to a decree for divorce. Section 7 of the Act has been deleted and it has been held by a division bench of this court in a Sally Joseph versus Baby Thomas 1999 1 KLT.